Okay, I think we'll go ahead and get started. So hello again and welcome to our estate planning webcast, which is brought to you tonight by the Office of Planned Giving at Stony Brook University. My name is Ashley Fetter. I'm the Director of Gift Planning at Stony Brook. We're so thrilled to have all of you here with us tonight, and we have a really wonderful presentation in store for you. It's my pleasure to introduce our honored guest and speaker, Merrell Bailey. Merrell is the managing partner at Your Caring Law Firm, which is based in Central Florida. She's committed to making estate planning as safe and comfortable for her clients as possible. Practicing as an attorney since 2001, Merrell limits her practice to planning with a focus on end-of-life issues, the unique needs of the elderly, unmarried couples, and individuals who hope to protect their family wealth from creditors and predators. Her overall practice areas include estate planning, charitable planning, asset protection planning, family limited partnerships, nonprofit organizations, and gift, estate, and generation skipping tax planning. Merrell welcomes and encourages questions throughout the presentation. So please, if you have something you want to ask, feel free to use the Q&A box at the bottom of your screen. And without further ado, I'll turn the program over to our expert. Merrell, thank you again for being here.
Terrific. Can people see the slides?
Looks good here.
Okay, terrific. Hi, I'm Merrell Bailey, and as Ashley so kindly said, let me get there, reading the slideshow. There we go. Come on, you. There we are. I am an estate planning attorney and probate lawyer down in Winter Park, Florida, which is just outside of Orlando. And we're going to talk today about the Wizard of Oz and how it's all about estate planning. So I'm going to use a lot of pictures of Dorothy and all of her friends, and they belong to Warner Brothers, but we're using them through the fair use of copyrighted materials for educational purposes. So let's assume that Auntie Em and Uncle Henry came into my office. What would I ask them? And how if they were you, what would I do? So I would say, okay, Auntie Em and Uncle Henry walk in, and I would want to know, well, what's their relationship? Are they married? Are they siblings? If they say they're married, are they legally married? Or are they married to somebody else? I had clients come in the other day, and it ended up that they've been together since 1992, but the wife was still married to her first husband, but they split up in 1991, and she just thought that because it's been so long, the marriage was over. And I was like, not exactly. So sometimes marriage is not as fluid as people think. So I would want to know what their status is. Now, I do know that they own a family business, which is a farm. And it doesn't look in the black and white photos like it's doing too well to me. So I'd want to be talking to them about, what do they have? I know they've got employees. Are they paying their employee taxes? Are they paying them? Are they doing things correctly? Do they offer any benefits? I probably wouldn't get into that, but I'd want to just make sure that for asset protection purposes, that nothing was going wrong with the running of the business that I could identify. So I find out, oh my gosh, there was a tornado and the farm suffered storm damage. And what can they do about that? There's different federal programs for it. There's IRS tax benefits that you can get for filing for storm damage. There's insurance claims. I'd want to make sure that they took advantage of everything they had to get above and beyond the farm damage. Now we get to Dorothy. Sweet little Dorothy. So Dorothy lives with Em and Henry. And I would want to know, well, who is Dorothy to Em and Henry? She calls him Auntie Em. She calls him Uncle Henry. But is she really the niece? Because there's lots of people who call themselves niece. Do they have legal guardianship over her? Are they fostering her legally? Have they adopted her legally? There's a very big difference between a child that you treat as your own and one that you've legally adopted. And what is her status? And is she just really this family friend that they have taken in because unless you've got legal authority over the child, you have no legal authority over the child. And I know that sounds so basic, but people tend to move children without any legal authority to do so. And then how do you register them for school? What have you taken to the doctor? Do you have any authority to make medical decisions? So I try to figure out who's living in the house and what is the relationship to that person. Now, Dorothy is a bit of a trouble child. She has a bit of a time with, the poppy seeds, and she hallucinates. The horses are purple and the trees talk to her, and she's got little people who are talking and singing, and she saw the witch fly by riding the bicycle. So Dorothy's got some issues. She is a truant. She's constantly running away from school. She ran off with her friends down the golden yellow brick road. She is not the easiest child to live with. She has questionable characters as her friends. She's constantly down by the waterfront hanging out with the guy in the trailer park. She has people that talk through machines, and she runs away with her 3 buddies. She also has a dog named Toto, who is a big problem. Toto bit the neighbor Gulch, and now there's a dog bite lawsuit. So that's an asset protection issue that I'd be talking about, that rotten little dog. She stole the house as a motorhome, and she drove it without a license, and she landed on the witch and killed her. Is that a vehicular homicide? Is it manslaughter? Is it a lawsuit that Auntie Em and Uncle Henry need to worry about, since it was their house? Now, when they would dump all of this information on me, I would be smiling and nodding, and I'd be taking notes like crazy. And I'd be thinking, oh my God, these people need financial planning for the business, and they need business succession planning because they're not so young anymore. And they need asset protection planning because they got the dog bite and the house on the dead witch, and they've got all these things, and they've got Dorothy. And I'd want to make sure that the first line of defense for asset protection planning is insurance. And making sure they had, homeowners insurance and auto owners insurance, and that they made sure that the dog was covered. And I'd want them to have a personal liability umbrella insurance. So I'd want them to have a lot of things. And then I also would want, of course, my part of this is the estate planning and the tax planning and the other things. So I'd be talking to them about all those things. I don't sell insurance. I don't do financial planning, but I work with their other advisors who would have that. So, financial planning, do they have any idea how much this farm costs them each year? Have they looked at how they're going to support their retirement? Have they even decided, can they afford to retire? Are they going to sit at the tractor for the rest of their life? Statistically, Uncle Henry would die first. How is Auntie Em going to go on? Who owns the farm? Does one of them own it? Do both of them own it? How are those things titled? I'd be talking to them about them and with their financial advisor about that. Well, what is going to happen to the farm after both of them are gone? Do they thought that through? Do they want it to go to Dorothy? Well, if Dorothy is not legally related to them and both of them die, Dorothy's going to get nothing. So we have to figure that out. Do they have a plan to sell it to the employees? Can the employees afford it? It doesn't look like it to me, but there are ESOPs and other ways to get a business to the employees that are very tax favorable. Would they want to sell it to a third party? Neighbor Gulch already has a lawsuit against it. Maybe she wants the farm. Or do they have charitable intent? They've got the league in the yellow brick road in the Wizard of Oz. They've got the League of Lilliputs, I think, and that's a charitable organization. Or they could talk to Stony Brook and say, we want to leave all this farmland on Long Island, and I know the farm doesn't look like much, but if you developed it, it'd be worth a fortune. So I talk to my clients about charitable intent, because very many people have charitable intent, but they just haven't had the opportunity to think it through. I'd like to give props for just a minute about family-owned businesses, because we are like the little engine that does. 64% of the United States GDP is contributed by family-owned businesses. We employ 62% of the workforce. We create 78% of all new jobs. Like family-owned businesses are really what is going on. We're not generally treated as favorably with the tax laws. This is one of my pet peeves with Congress, but family-owned businesses are the engine that runs the United States economy. When a family business wants to drop the business down to the next generation, so when we're looking at family, succession planning, is this a multi-generational business? And the answer is usually not, sadly. The only 19% of them go down to the second generation. It used to be a much higher number, but now it's only about 19%. And most families think that the next generation will want it. But what I see happen is the first generation spends all their life building up a business, and their kids have seen how hard they worked for it. I have dear friends who own a diner. The family is Greek. They own a diner. They came over from Greece. They opened up this diner. It is very, very successful. One of their children has a master's degree and is working in Washington, D.C. in international business. The other one is an architect. Those kids want nothing to do with the diner because they saw how hard their grandparents and parents worked for it. Their kids are never going to see the grandparents and parents how hard they worked in the diner because they're never going to see really the diner. They're going to be too young by the time the diner closes because the parents and grandparents are just not going to be able to work anymore. So the third generation doesn't see the hard work that the second generation does. Those kids just see the benefit of it because their parents were architects and MBAs. So it's a really interesting thing to watch a family-owned business that is just been this life force for one generation, and it just is not the plan for the next generation. And that's a hard thing for the founders to recognize sometimes. Not always, but sometimes. Now, when I talk about asset protection planning, what I mean is I'm looking at what do people own, and if they were in a car accident or they got sued for some reason, what could that creditor take? Now, there's all sorts of different things that get protected, and a lot of this is controlled by state law. So I'm down in Florida, and Florida homestead is revered across the country because it is almost impossible to get the Florida homestead unless the mortgage company can get it. The federal government can get it in certain instances, not all. And other than that, unless you have put a lien on that house voluntarily, no one, like American Express, cannot come and take your house in Florida. So homestead in Florida is a very big deal. Retirement plan wealth in Florida is also protected. It is protected in a lot of other states. Now, that protection sometimes inures to the next generation. So if you leave your IRA or 401k to the next generation, in some states, it's protected for the next generation as well, but not all. Life insurance, the policy, the proceeds, the cash value, Florida protects that. Not all states do. Annuities, all those are protected in Florida. Now, non-homestead real estate, second houses, third houses in different states, we have to look at those and say, okay, this would be protected in Colorado, but because it's in Utah, it wouldn't be protected. You're in upstate New York, you're a New York resident. Is this your homestead? Is it not? We look at each thing. It becomes very factual. Limited liability companies, partnerships, corporations, those were all designed with the idea to protect from inside liabilities and outside liabilities. And each one of them has a little bit different take on that. And then we get to cash or brokerage accounts. And generally, if you have a checking account or a savings account or a brokerage account that is only in your name by yourself, it is not protected. So what I do is I look at, well, let's set up a family limited partnership, and we'll take the brokerage accounts and we'll put that in there, and we'll start transferring wealth amongst generations. And it offers tax benefits. It offers asset protection benefits. There's all sorts of reasons for it. So insurance protection, again, I want everybody to have great insurance because it really is the first line of defense. I want them to have an umbrella policy, automobile, homeowners. Florida is big on flood policies. You know, we have hurricanes, which you guys actually have started getting too, but they're more in the news now. We have hurricanes, but hurricanes generally cause wind damage, and the hurricane policy is covered under homeowners. But the most devastating damage generally is a result of flooding, which is a byproduct of the hurricane, but it isn't hurricane damage under Florida law. So you have to have a flood policy or you're out of luck. So we look at all of those things. Of course, I want everybody to have a health insurance. Some people need disability insurance, and long-term care is insurance that would be delightful to support you in your old age when you are too frail to support yourself. But it is generally very difficult to get the policies. They're expensive, and medical conditions make it really hard to get them. So it's a great policy if you have it, but a lot of people don't get it. And then life insurance. Life insurance is an investment like anything else. It is a way to get a cash infusion at a death to continue a lifestyle. For the survivors, it is a way to bring cash in at a death to pay estate taxes. In certain states like Florida, it is a great way to plan for retirement because you can overfund the universal life policies, not the term, but you can overfund them. And under Florida law, that overfunding is an investment and it is protected. And then you start taking it out when you retire. And it's just a really neat thing. So I'm a CPA as well as an attorney. And when I was a CPA, I was a CPA first. And I would be like, oh my God, why are people paying for a universal life policy? They should just get term life. It's so much cheaper. And then I went to law school and I'm like, oh my gosh, there is a use for life policies that are universal, or, the bigger policies, and not just term. So don't discount term life. And yes, you have a plan, or someone asked why you've got we have a question about why you have a planner from Florida. I volunteered to do this, and yes, some of the things I'm going to say are about Florida. I'll bring in New York as much as I can, but you will be getting, I'm sure in the future, more New York people. And most of the things that I'm talking about are fairly generic, so hang in there. Next slide. Okay, basic documents, and these are Florida or New York. We will, these apply everywhere. When you are looking at estate planning, the basic 5 tend to be everyone who is an adult. Again, Florida's 18, New York is 21. Durable power of attorney is a document that everyone who is an adult should have. That document allows someone to step in your shoes and be you, and to handle your affairs depending on whether it is a springing power or a regular power. A regular power is effective the moment you sign it. A springing power only is effective when you become disabled or incapacitated. So depending on the state and depending on what you want, your power will be either springing or in effect. But what that does is you think as a parent that no matter how old your children are, that you'll be able to handle their affairs, right? They're your children. It doesn't matter whether they're 14, 44, or 84, it's still your baby. Nay, fluffy. The moment that child is considered an adult in that state, you have no authority over the child legally. And if the child is in a car accident, the child gets arrested, there's all sorts of things on there that you may need to help the child, but legally you are not allowed to. And very often this comes up with children that have some form of medical condition. And you as the parent have always gone to the doctor visits with the child. And all of a sudden your regular doctor's like, the child's now 25, we don't care. But then you get sent to a specialist and you start to enter the room with the specialist, and the specialist's like, I'm sorry, I need to speak to the adult alone. And you're like, but I'm his mother. Yeah, you are, but you might not have the authority to help the child in that way. So if you don't have a durable power of attorney, the only way to get that authority, if needed, is through a guardianship court. And that is expensive. It's public record. There's all sorts of, think of Britney Spears, right? Her conservatorship is a form of guardianship. It's a different name for guardianship, and everybody's been paying attention to that. If she had had a durable power of attorney, that all could have been private. Please, everyone, we laugh about when we say to our clients, when your children are going on the way to their birthday on the age of majority, swing them by on the way to eat cake to sign a durable power of attorney so you've got one. Healthcare surrogate is a form of power of attorney. It is very limited. It only allows people to make informed consent medical care decisions to keep you alive because they think you're going to get better. Flip side of the coin is living will, which is the pull the plug document. If there is no hope you're going to get better. Again, these are forms of power of attorney. You don't have to name the same people for each of these documents. For the durable power of attorney, because the information or the rights are for your financial rights and for civil rights, like where do you have the, to move you, to make decisions for you. Those can be civil rights. You want somebody that's really good with paperwork. Healthcare surrogate, you want someone that's familiar with the medical system, and has the time to go to doctor's appointments with you. And for the living will, you want a bulldog that has the courage to say to the doctors, stop treating my father. He would not like to live like this. Please take away the life support. And that is a very, very difficult thing to do. So think through who has in your sphere of people who love you, who has these values and will follow them for you. Now, a will, the last will and testament, is a document that says where you want your wealth to go. In the North Atlantic states, will-based plans are probably much more popular than they are in Florida. And I keep bringing this up because so many people want to retire to Florida because we don't have an income tax, we don't have an estate tax, we don't have many taxes, our sales tax is less. There's a lot of taxes that are less than New York, New Jersey, Pennsylvania, and the other states up there. So a will-based plan means that you have created a will, and the will says where you want your where you want your wealth to go. But it will go, the transfer of title will actually occur through the probate court. If you do not have a will, you're considered intestate. Intestate merely means you didn't have a will, your title transfer is going to go through the probate process, but the state law is going to say who inherits. Not necessarily where you want it to go, but the state has an estate plan for you. State of New York has an estate plan for you, and it says who will inherit your wealth if you haven't taken the initiative to do a will-based plan. Now, there are other ways of transferring wealth, and we'll go over that in a minute, but the will is a method of transferring wealth after you die. A trust-based plan is the next step. It is a document in addition to as part of an estate plan, and it is more prevalent in Florida because Florida is very trust friendly, because the probate process in Florida is much longer and more convoluted than it is in the North Atlantic states. So most people who have an estate plan in Florida will end up having a trust-based estate plan, whereas you might have a will-based estate plan in that same situation. Same couple in New York might have a will-based plan, just different states, different flavors. Each of the will-based plan and the trust-based plan get you to the same place. It's just that the path that takes you there is a little different. Now, if I were talking to the Gales about their estate plan, the first thing I'd want to ask them is Dorothy. Like, if they tell me that they want Dorothy to inherit, I would say, I don't really want Dorothy to inherit outright. We know she has substance abuse problems. She's got some other issues going on. We don't like her friends. We want to protect her from her poor choices. So I would look at leaving the wealth to Dorothy in an asset protection trust for the benefit of Dorothy. Now, whether I get to that trust through a will-based plan for Henry and Ani M, I can get to Dorothy's asset protection trust through a will-based plan for them or a trust-based plan for them. And I would talk to them about that. Now, now when I talk about a trust, I'm sorry, let's talk about taxes for just a minute. I have this is a chart that shows what the federal transfer taxes have been from 2010 to 2022. And I am showing you this chart because we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 different tax scenarios have been the law from 2010 to 2022. Congress is talking about changing the tax law again. These are the federal transfer taxes. And when I talk transfer taxes, I mean not an income tax. Income tax is completely different. The transfer taxes are an excise tax on the privilege of transferring wealth. If you transfer wealth during life, it's subject to the gift tax. If you transfer wealth at death, it is subject to the estate tax. And if you have a transfer that was subject to the gift or the estate tax, and the recipient is someone who is a grand by bloodline, or someone who is 37 and a half years younger than you, if not related to you, then it gets taxed twice with the gift and estate tax, gift tax and the GST tax, or the estate tax and the GST tax. So I'm a big believer in making sure we are not subject to that. Now, right today, each of us in the United States has $12.06 million we can die and leave for free. As a married couple, you get to double that. So as a married couple, you have $24 million you can die and leave for free. Back in 2010, that was $1 million each, and you didn't get to combine it as a married couple. So that's a huge difference. Back in the day, back when it was $1 million, and before that, it was $600,000. So back at that time, so much of estate planning was done for tax purposes. It was done to avoid the estate tax. Now, 99.9% of the people are not subject to the federal estate tax because they've got $12 million, $24 million as a married couple. But if, Congress is talking about changing that number down, and if Congress does nothing, the number is going to go down in 2025 anyway. This number is going to sunset in 2025. So if Congress does nothing, the number is going to go back down to 5 million. That is going to be adjusted for inflation. So it'll be somewhere about 7 million if Congress does nothing. If they do act before 2025, we have no idea what it's going to be. They're talking about bringing it down to the 5, which would be 7. So your guess is as good as mine as when it will happen. It will happen. But I do know that if they do nothing, which is always, if they don't, they're not the most functional group. So if they do nothing, it will still go down and it'll bring a lot more people back into the fold of estate tax. Now, when we're talking about assets and how they transfer title after a death, there's 4 ways. What I do is not rocket science. It is merely organizational skills. I look at what you own and I say, oh, do you own it with someone else? And that person has rights of survivorship. If yes, it goes in the top left quadrant. That is quadrant 1. If you own something that has a beneficiary designation, such as a retirement plan or life insurance, or you have a bank account that says payable on death to someone, that goes in quadrant 2, the top right. That goes immediately after the death without muss or fuss. So the top half of this sheet, you could do an estate plan with me that says you're leaving everything to Stony Brook University's football team. And if all of your assets are in quadrant 1 and quadrant 2 in the top half of the form, the football team is not going to be able to buy new shoes next year because all of the assets transferred outside of your estate plan as part of your estate plan, but not by the legal documents. If you own assets by yourself, So you're a married couple, one dies, leaves everything to the survivor. Now the survivor owns everything by his or herself. Let's assume it's a she, you own it all by yourself. That is the third quadrant, which is bottom left. That is the probate quadrant. When you die, the assets will either go intestate if you have no estate plan. If no will, they will go through the probate process if you have a will-based plan. Or you could set up the fourth quadrant, which is a revocable trust-based plan that is your will substitute. And the trust will then transfer your assets after you die to the next generation, again, or next people. Exactly the same result as a probate will-based plan, but the trust has two benefits. First of all, it's much quicker because you don't have to get the court involved. And second, it is private. The copies of your trust are not filed with the court. I talk about James Gandolfini all the time because I know I have a copy of his will because he had a will-based plan and it was filed with the New York courts. You can get anybody's will in any court. It's public record, but it used to be harder to get them. You had to actually go to the court and ask for a copy or read the file right there. Now everything's online. You can get copies of things you shouldn't have to. Now I have a question about disclaimer trust versus revocable living trust. My definition of a disclaimer trust is a revocable trust that says all to spouse, but if for tax purposes, I want to not inherit it as the spouse, at the time of death, I am going to disclaim the portion from my deceased spouse, and I'm going to keep it in a qualified terminal interest. I'm going to keep it in a marital trust so that I've got access to the wealth, and I've got access to my wealth, and I have access to 100% of the wealth, but part of it is in my column when I die to be subject to estate tax, and part of it was subject to estate tax at the first death. So I'm a big fan of disclaimer trust because right now, so many people don't need two trusts after the death, but depending on it's a very factual discussion based on their assets, how they're titled, do they have children from different marriages? There's a lot of fact base in it, but generally the disclaimer trusts are written through the revocable living trust. Now, we went through all this. Again, operational law, contract, probate, revocable living trust, it's all there. Will versus trust, you get to the same place. We've talked about all of this. When we're talking about a trust, all we're talking about is a contract that has three acting parts. That's it. If you look at any trust and you say, okay, I've identified the grantor, the trustee, and the beneficiary, you have figured out the big part of it. Now, like a guitar, you can take the words of this trust and make 1,000 songs out of it. But if you know who the grantor, the trustee, and the beneficiaries are, you've got it. There are two ways to create a trust. You create a trust during your life, or you create a trust at death through will. Again, it just depends what you're trying to do and where you're trying to get to. There are only two types of trust. So again, there's so many things that it is or it isn't. A revocable trust means it is generally a trust that you use for estate planning to be the vehicle through which you transfer title of your assets at death. It is revocable so that you have the right to change your mind. You might say, I want to leave a third to each of my kids. And then later you're like, gosh, I really don't like my son Chip. I'm going to cut him out. You would have the right to change it if the trust is revocable. An irrevocable trust is a trust that you have given up the right to change your mind. The grantor no longer has the right to change the words. So these each have a place. Generally, I would call it a gifting trust. If I was setting up a trust during life for the people to transfer money to their children during life, I would set up an irrevocable gifting trust. And that would be set up now. Then I would have their revocable living trust would say, I'm leaving all the wealth to my children in their gifting trust. And I would have the terms of the trust where they leave the money when they die to be the terms of the gifting trust, right? I mean, they are not mutually exclusive. They generally work together. There's all sorts of reasons to have them. The trust words, the grantor is responsible for what the words say, and the grantor can make them say anything they want them to say. The trustee's job is to know what the words say and who are the beneficiaries and what the assets are. So the trustee wears two hats. They invest the assets and they administer the assets. They pay bills, they file tax returns, they do all the paperwork. So the trustee has to know who the beneficiaries are. They have to know all the words, and they have to make sure that the assets are handled properly. And then they have to spend the assets on the beneficiaries in accordance with the words say. Again, the advantages of a trust-based plan: mostly privacy, avoiding probate. It can avoid guardianship, and the attorney's fees generally are far less with a trust-based plan than they are with a probate with a will-based plan. They tend to be more sophisticated. They can protect against predators and creditors. But again, we can get the same place through a will-based plan, and the Florida probate court takes a lot longer than New York's. So will-based plans are not the devil. They're just a different way to get from point A to point B. That path in New York is not as long as convoluted as it is in Florida through the probate court. Ancillary documents, we already talked about those: door power of attorney, healthcare surrogate, and living will. We've already discussed those, but there are a couple others that people come to me and ask about. The do not resuscitate document and the medical or physician's order for life-sustaining treatment, the POLST or MOLST. New York has a MOLST, medical order for life-sustaining treatment. A do not resuscitate order is a physician's prescription, and you are saying that if I go into cardiac arrest, I do not want to be resuscitated. It's very narrow. A MOLST, or medical or physician's order for life-sustaining treatment, much more broad. You can talk about all sorts of things that you want to have happen in many, many circumstances. So the DNR is very limited. The MOLST is much more broad. Under Florida law, we do not have a MOLST or POLST. They're talking about it, but we've not gotten there. So we just have DNRs. But you in New York have the privilege of having the MOLST. So take advantage of it if that's important to you. And then the disposition of human remains. Under state law, if you die and you're married, your spouse has the right to take care to handle your funeral. If you are unmarried but you have adult children, it's the adult children. Like there's this statute that says who can handle your funeral and the right to handle your body. I bring this up because this is so important with unmarried relationships, whether you are gay or straight. If you are not married, your life partner has no authority whatsoever to handle your physical body, your physical remains after a death. And there have been very many instances where the family swoops in and takes over and doesn't tell the loved one where the funeral even is or where you're going to be buried. And it can be very hateful. If that's in your wheelhouse, pay attention and get the disposition of human remains document handled. You can also do this fairly easily by just prepaying for your funeral or cremation. We've talked about all of these. Charitable gift planning. I'm going to turn it back now to Stony Brook, Ashley, and we've got a couple questions I did not answer. Ashley, if you want me to answer them after you're done.
Sure. Hold on, let me just get my notes up. Okay, so thank you again, Merrell. That was all great information. You know, again, we know that Merrell is based in Florida. This is a general estate planning introduction. Its purpose is to help you be able to start thinking about your estate planning, take your questions back to your local attorneys. And also we do have a number of graduates and alumni who retire to Florida. So before we open the floor to last questions, I do want to take a chance tonight to mention charitable gift planning and talk about when it might make sense to leave a gift to charity in your estate plans. Gift planning really works hand in hand with your estate planning, and it helps to maximize the benefits of your estate for your family and also for charities you care about. Many people have a very binary or either or perspective to estate planning. They think, okay, I can choose to support my loved ones or I can leave a gift to charity. Much of what I do as a gift planning professional is help our friends and donors see you don't have to choose. The right plan can help you achieve and maximize your personal financial goals and your philanthropic goals. So when should you consider including charity in your estate plan? Well, I'll tell you, the driving force behind this decision for many of our donors is their tremendous devotion to Stony Brook. It's really not uncommon for us to hear from an alum that their time at the university set them up for the success they enjoyed during their lives. Or sometimes we'll talk to a grateful patient whose life was saved by the hospital, or someone who cares deeply about our advancing research. If this resonates with you, if there's an area at Stony Brook that you're really passionate about, then an estate gift might be a good fit for you. Some of our donors are motivated by their desire to leave a legacy. You want to create something lasting that represents your values or that teaches your children about philanthropy. You may already be very philanthropic and you want to learn how to maximize your charitable contributions and your impact. Maybe you'd like to see a fund name for you. Well, then an estate gift is definitely something you should consider exploring. Some other considerations. Our legacy donors enjoy tremendous tax benefits. Now, this could be in the form of taxes to their estate, like Merrell mentioned earlier in her presentation, or enjoying tax advantage giving methods that benefit them today. Some donors set up gifts that provide them with life income and help diversify retirement income. Others use gift planning to help protect assets from the 5-year Medicaid look-back period, for example, or they might be experiencing what we call an equity event, which is like the sale of a home or a business, and they're using plan giving to help them balance that sale. Usually the motivation is a combination of these factors. But I really want to encourage you tonight, if you have a vision for your legacy or you want to explore some of these type of benefits, I welcome you to reach out to me directly. What I do here at Stony Brook is sit down with our donors one-on-one. We talk about your family's needs and priorities. We talk about significant life events you might be coming upon. And then we brainstorm some giving solutions that could benefit you and your family and allow you to impact an area you care about at Stony Brook. Can you advance me to the next slide, Merrell? Thank you. So it's important to keep in mind when you're starting your estate planning that not all advisors are, like Merrell, that not all of them are going to bring up the option of charitable gift planning unless you make them aware of your interest. So if you do have a charity you care about, be it Stony Brook or your church or another nonprofit you might be involved in, you want to consider how to include them in your estate plans, be sure to mention it to your financial advisors, your estate attorneys, even your accountants. And also feel empowered to use your favorite charities as your resources. As I mentioned, Stony Brook has a dedicated office of gift planning. We help you come up with a customized gift plan that you then take back to your advisors to review and make sure it fits into your overall estate plan. Next slide, please. So, lastly, if you're interested in exploring the idea of gift planning, but you might not be ready to talk to your advisor or your charity about it, a great place to start is our webpage, stonybrook.giftplans.org. There's a plethora of resources on the site. I've included a screenshot here of one of my favorite tools. It's called the Life Stage Planner. It essentially walks you through some financial considerations you might be considering based on your age, and it suggests charitable gift options that you may want to look into. Okay, then our last slide. As we move to the final questions, I'll leave this slide up with my contact information. If you have questions about Merrell's presentation today, or if you want to have a gift conversation with me, or you have questions about gift planning, please don't hesitate to reach out to me directly. I'll also mention again, Merrell is licensed to practice law in the state of Florida. So for any of our friends and graduates from the Sunshine State, we encourage you to reach out to Merrell if you're interested in exploring estate planning needs further. Our office at Stony Brook also has a list of estate attorneys that are based in Nassau and Suffolk and even Manhattan. So if you're local and looking for planning experts, please reach out to me as well. And with that, we'll go to our final questions.
Okay, so I have one question, which is one of my favorites. Can a beneficiary be a trustee also? And the answer is, it depends. And you need to know, like I was a CPA forever. And one of the reasons I went to law school, because I got so sick of asking a lawyer, I'd be like, 2 + 2 = 4. And they're like, well, that depends. I'm like, oh my God. So I went to law school and now the words choke me when I'm coming out. Sometimes they can be the trustee. Often they can be the trustee, but not always can they be the trustee. Is it beneficial to add your children to your house deed so when I pass, it would be easier for them to handle my estate? I am not a fan of adding children to your house deed. I am not a fan of adding children to your checking account. I'm not a fan of adding children to any of the title of your assets, because if you have a general durable power of attorney, they will have the authority to pay your bills on your behalf without being on the deed of the house or on the checkbook. But if they have a car accident or they get divorced, the creditor can go after your checking account and perhaps your house because their name is on it. So I am not a fan of having the children on the house deed. There are different types of deeds that are kind of like payable on death deeds that would let the house go to the children quickly. A life estate deed or an enhanced life estate deed would get the house to the child outside of the probate court, but it would not give them generally a interest in the house, or that right now that could possibly be taken by a creditor. So not a fan of adding the children to the title of your assets. I have a question about a home left in a life estate with remainder beneficiaries versus a home that is titled in a irrevocable trust, and which is better. Yeah, there's really not a better. It is, each of them are very fact-based answers. So a deed that is titled as a life estate is a deed that the house, the rights to the house have been split into two parts. So a traditional life estate deed says, I own this house and I am changing it from me owning it fee simple into me owning a life estate, which means I have the right to live in the house. I have the right to pay the taxes on the house. I have the right to pay all the bills on the house. But the moment I die, the rest of the house goes to my kids. My life estate dies. A life estate, a regular life estate deed, gives the remainder beneficiary an interest in the house right now. So if you want to sell the house, they have to sign the deed. So I'm not always a fan of a regular life estate deed. There is something called an enhanced life estate deed. It's also called a ladybird deed, which is a form of deed that says, I own this house. I can do anything I darn well please with it. But the moment I die, the house transfers title to the next person. That's like a payable on death deed. Not all states allow ladybird deeds or enhanced life estate deeds, but when in the states that do, and when the situation merits it, life estate deeds, ladybird deeds are the greatest thing since sliced bread. A home left in an irrevocable trust, if to have your home titled in a trust, yes, there needs to be a deed that takes the house out of your name as a human and puts it in the name of the trust. So you can't just say, hey, I want my, I'm writing this note on my back of an envelope saying, hey, I want the trust in there. Yes, so you can put a house in the trust. We do it very often, but there's times we do it and times we don't. It's very, very fact-based. But if the house is in the trust, the house transfers title after the death, according to the words of the trust, by the trustee afterwards. So it's just different ways of getting there. I have a question about irrevocable trust. Can an irrevocable trust ever be broken? The answer is yes, it can. Irrevocable trusts have never truly been irrevocable. We've always had the right to go to court and file a lawsuit to get the trust words changed, right? Because really that's what you're trying to do. You're trying to change the words of the trust to say something else. The grantor is dead or made an irrevocable trust, and so there's no one there with the right to change the words other than a judge. It's very expensive. It's public record. It brings all your family business, public. It's not the greatest way. So a more recent way of drafting an irrevocable trust, and the way I do it, and many people do, is we add what is called the trust advisor or trust protector into the words of the trust. The trust advisor or trust protector, as it's called in many states, is this person or this mystical being that in the future, when the trust is irrevocable and there's something wrong with the words of the trust, you can bring in this independent third party. Think of Tinkerbell. Tinkerbell would fly in, and her job as the trust advisor or trust protector would be to look at the trust and say, oh my gosh, yes, the tax laws have changed. Something has changed. Something, is really wrong with this trust that was not foreseen when it was set up. And I agree that the words need to be changed, and I have the authority to change those. So I'm going to change those words to be the right words. Tinkerbell also has the duty to say, nay, nay, Fluffy, just because you, beneficiary, don't like the words of the trust is not broken. There's nothing wrong with it. It's just that you don't like it. And it is my fiduciary duty to not change the words. So there are different ways of changing or breaking an irrevocable trust. It just depends on the words of the trust to see whether or not, what it says and how it can be done. A house can be placed into any kind of trust. It can be placed in a revocable trust. It can be placed in an irrevocable trust. It just depends what you're trying to do with the house and the trust. Under recent tax changes, inheritors of 401ks, 403bs must withdraw them within 10 years and pay taxes at their tax rate. What do I suggest to minimize the taxes in this situation? This tax law was such a kick in the head. I used to do such brilliant estate planning, like leaving 401ks or IRAs to the 2-year-old grandchild, and we would take it out, and it was just brilliant. And now it's not nearly so pretty. There's not a lot.
Merrell, there's actually a charitable gift plan that a lot of people are considering because of this recent law change. So if people are unfamiliar with the law, the Secure Act, which was passed a couple of years ago, you used to be able to take your IRA and pass it on to your kids, and they could turn it into what's called a stretch IRA, and they could take the distributions over their lifetime, and that would help minimize the tax implications on those payments. Now, when your kids or family members inherit your IRA, you have to drain that fund in 10 years. When you pass, a lot of times your kids are in their highest income earning brackets. So some people, depending upon their income brackets, can lose up to 60% of that money to taxes. So what a lot of people decide to do, it's called a charitable remainder trust. So you do have to work with a charity. There is a gift to, a charity at the end, but essentially it can stretch out. It mimics what a stretch IRA used to be able to do, and it can stretch payments out to your kids or other beneficiaries for their life. And after their lifetime, you also get to make a fabulous gift to a charity. So if that's something you want to consider, please feel free to email me, and I'm happy to give you some more information.
So one other thing is the 10 years does not start until the inheritor is an adult. So this is another place where you might want to consider leaving it to the youngest child, or the, if you left it to a 6-year-old grandchild until they're 21, then they would have to start taking it out over the 10 years. So there's some rules about it. Is it a wise strategy to have all banking and brokerage accounts be payable on death? This is a fact-based question. I do this a lot. I have the banking and brokerage accounts titled as Shelley and Aaron spouses, payable on death to the Shelley and Aaron Revocable Living Trust. That's because I want to keep the asset protection of tenants by the entirety during their life, but I don't want to have to go through probate at death. If I want the bank account to go directly outright to someone and not in trust, I can make it payable on death. There's 17 different reasons why yes, and 17 different ways to be no. And that's something you really need to talk to your estate planning attorney about, because if you have the bank account payable on death, back to I have everything leaving to the Stony Brook football team. But if the bank account is payable on death to my next door neighbor, even though the estate plan says the football team gets it, if the bank account is payable on death to the neighbor gets it, not the football team. And that's all the questions that I have. You have anything else?
I think that's it. So in closing, Merrill, we just want to thank you again on behalf of the entire Stony Brook community for sharing your estate planning wisdom with us tonight. I think we all have to go home and watch The Wizard of Oz now. But I truly enjoyed the presentation. I know our guests did as well. So thank you everyone for attending. Please feel free to use our contact information and reach out to us if you have any additional questions. One question, can we get a copy of the slide? Merrill, I guess that would be
It's
up to
fine
your
with me.
comfort level.
Feel free. Contact Ashley and she'll be happy to send them on.
Okay, great. So we'll stay on for another minute in case anybody has any other questions. If not, thank you again for attending. So another question.
Ashley, we got a question about a recording. Was it recorded? I don't know.
Yes, this was recorded. It's going to be placed on our Stony Brook YouTube channel. We'll also follow up with a link to anyone who participated. So you'll get a link to the recording. Vinod, did you have a specific question about a disclaimer trust that we didn't cover?
I think I answered that. I answered the trust about disclaimer trust versus other types.
Okay. So if you do have another question or you want to dive into a little bit more detail, just shoot me an email and we can ask Merrill to elaborate a little bit more. Okay, Merrill, I think we're safe to sign off. Thank you again, everyone, for attending. And thanks, Merrill, for all your time.
You're welcome. All right. Bye-bye.
Bye.